Hello, everyone, and good afternoon or good morning, and welcome. This is Cecilia Friedman-Levin, and I am Senior Policy Counsel at ASISTA, and I am delighted to be joining you today with our newest and most wonderful staff attorney, Amy. Amy, thanks so much for being here and for joining us.
Thanks, Cecilia. I'm really excited to be here with you all today.
And so we are going to, again, this is a webinar sponsored by the Office of Violence Against Women and the DOJ. And we're going to be then covering today some emerging trends in your U-Visa practice, including VAWAs and Ts and kind of what we know about what issues that people are facing. We're going to talk a little bit about complex issues of inadmissibility, which might come up in various stages of your case. How you prepare that case if you are responding to requests for evidence or notices of intent to deny, and so how to kind of present those issues when you do have those complexities at play. And then think about other forms of relief for survivors of domestic violence and sexual assault, and to make sure that we are considering, what else may be on the table, kind of given all of the different issues and problems that we are seeing in processing delays, particularly in the U-Visa context. And so these are some of the issues that we are going to be covering today. And to the extent possible, we are going to make it as interactive as we can. These webinars are really opportunities for us to learn from you. And in looking in this wonderful participant list, I see people who could give this presentation for us. I won't call you out, but I could. And so I might kind of turn it over to you to kind of see how you face these different issues, how you work to address admissibility issues, what trends you're seeing in your cases. Because as you know, identifying these issues in a case-by-case level helps us to identify these systemic problems. And so in as much as we can learn from each other and kind of make best use of this chat box, then I think that we are also look forward to learning about the things that you're seeing and how you're approaching these cases. So with that, let's move on. So we're going to talk about now kind of trends in adjudication and what it looks like for U's and T's and VAWA. And to start that, I am going to kind of start with some charts. And this is a chart that comes from the U-Visa data set, which is a file that you should see in the box kind of underneath the chat, where you can kind of look at the very last file, which is I-918 U-Visa statistics, if you want to click on that. And so this is information that is released by USCIS on a quarterly basis. And it says how many applications were received, how many were approved, how many were denied, and how many remain pending. And it does that for every quarter. If you can see there, this is inclusive of the first quarter of FY 2018. And so this is what it looks like for visual learners for U-Visa principal applicants. And as you can see, at the end of fiscal year 2017, there were 110,000 principal U-Visa applications pending. And you can also see that for principal filings, that they're receiving around 36,000 a year. And that you can kind of see from about 2016 to 2017, it went from 35 to 36. But you can also see that, if you look at it in the totality, from about 2009 all the way up, that it has been steadily increasing and making sure that it's like 16,000 in 2011 and over doubling that in 2017. And then you have the orange line there, which is the approved, and that is pretty consistent vis-a-vis the U-Visa cap, right? There's only 10,000 principal applications or visas. There's only 10,000 visas available per year, and that the number of principals is what goes towards that cap. And then you can kind of see also the denials. And so where does that look like now? Where are we kind of after the data for fiscal year 2018? Right now, they have 117,000 principal applications pending total. And then there's 117,000 principal applications pending. And there's over 201,000 applications pending if we include principals and derivatives. And what do we know about that pending number? The answer is not much. But that pending number is inclusive of the number of cases that are on the wait list and cases that are just waiting to get their files opened. If I had to guess, and if people on the phone, maybe we can stop and ask here for a moment. If people can put in the chat box, if you've had a U visa case placed on the wait list, what are the latest dates that you have been receiving for cases on the wait list? Cases that were filed in what month and year? Okay, so Carmen says that she has a case filed in October 2014. Elizabeth, September 2014, October 2014. And so this kind of shows us May 2014. So this is kind of showing us that it's the summer, the fall of 2014 for the wait list. Anyone after October 2014? Oh, November. There we go. So I feel like it's an auction. Do we have October? Do we have November? But okay, oh, December, wow. Okay, so we can kind of get a sense then, right? We're going to talk a little bit about kind of how USCIS, and I'm sure that you know, has changed their processing time. And so the last date that they had before they started giving that period was August 2014 as a date that they were working with in order to put cases on the wait list. So as you can see, August to about November, or outliers of December, are the cases that they're working on for the wait list, which to my mind means the vast majority of these cases are just waiting to get their files opened. Now, if I can ask another question, how many cases are for the dates that you're actually getting U visa issued, the full 4-year visas? What are those dates? Cases that were filed in what month? Okay, May 2014. Okay, so we're not really working with that big of a difference. So we can kind of see September 2014 for a full U visa, Catherine. So May through July. So we can see here that the time frame between the issuance of the U and the wait list is not a big one. And so I think that's important to keep in mind as we're kind of counseling our clients through this process, that really the vast majority of these pending cases are just waiting to get their files opened for the first time. And so I think that that's kind of interesting to see. If you're getting full 4-year visas for August 2014 and you're only getting cases placed on the wait list, maybe we'll say around October, that's just an important time frame to kind of keep in mind. Now we're going to move on to VAWA. And again, these statistics are kind of put into this little chat box. You can follow along if you're like me and like to see charts. And this is what the data is on VAWA. So for the fiscal year 2017 and including the data for the first quarter of 2018, they have received about 12,000 applications a year for VAWA. They approved 4,300. They denied around 2,000, which I think is interesting. If you can kind of look at the cases that were adjudicated in the last fiscal year, that about 35% of them was denied, and I think that is just a significant thing to look at, and that there's about 14,000 of these applications. And this is the data on T visas, and again, these numbers are much smaller than something that we saw for the U visa program when it goes all the way up to 120,000, and for T visas, the highest we go here is around 1,200. So these numbers are much smaller. And so the thing that I think is interesting here is that for the fiscal year 2017, They had over 1,100 principal applications, which I think it is the highest that it has ever been. And so we're going to talk a little bit before about kind of thinking about trafficking in the context of cases you might see for domestic violence or you might see for sexual assault. But these numbers, as you can see, are significantly lower in terms of the filing. There's a 5,000 visa cap on T visas, which has never been met since they started issuing them. So I just think it's interesting to kind of start this application and start thinking about these just in terms of numbers. And I promise that's the last of my charts for now. Okay, so what do we know about why is this significant delay? We have this huge volume of cases. We have cases that are being put on the wait list and adjudicated kind of in that same time period. And that is because at the last count, according to the 2017 CIS Ombudsman report, there's about 60 adjudicators working on the U visa program. 60. And so that means that that contributes to the significant backlog that we are seeing in the adjudications of the cases, is that there's simply not the person power to move more quickly than that. And as you might have seen if you visited the USCIS website lately, that they have changed the way that they have posted their processing time. They used to give you a specific date. The last one was August 25th of 2014. And now they've shifted to doing more of a time frame. So for volatile petitions, they said the posted processing times should be between 15 and 19 months. For U visas, between 42 and 54.5 months, which if you had to do math, that was about 4.5 years. And then the T visa, which is about 10 to 15 months. And in addition to these time frames, they have posted what they put, these case inquiry dates. And that is when they have said that if you have a case that has been pending longer than those dates, then that is when you should reach out to them regarding their case processing time. And so this is something that has been a very recent change in terms of how they have both posted the processing times and when they want to hear from you for a case that is outside of process. And so a word on adjudication. So USCIS utilizes a first in, first out process. A few years ago, they started prioritizing cases for Supplement A for family members for when the U visa applicant had a full 4-year visa, but they are no longer doing that. And so they are now kind of putting everybody from, even if you are filing a derivative application for a U visa holder, everyone goes into this first in, first out process. The older cases have been from, are kind of transferred to the Nebraska Service Center. A few years ago, they started a U visa work share at the Nebraska Service Center. And at my last count, there's about 24 adjudicators at the Nebraska Service Center working on U visas. And so we have approvals from September 14 were transferred to NSC. If someone has gotten a transfer notice recently, what dates have they gotten transferred for? To Nebraska. Okay, so we'll wait for that to come in. Maybe they have an issue. But it seems like those cases, the older cases, if they're coming from September 14, that those are kind of at the Nebraska Service Center. So we already kind of talked about, so December 2014 was from Nebraska Service Center. So again, what you talked about, kind of what we already discussed about the wait list and about the U visa issuance, is consistent to the trends that we're seeing. And so I think that is something we can kind of keep in mind for, that if I had to guess that the U visa issuances is going to kind of be between the summer and fall of 2014, because USCIS works on these kind of time frames when they're issuing U visas. And so what you've noticed as trends is consistent to what we're seeing as well. So, all right, so these are, for the next transferred, we have from September, August, so spring to summer 2015 for transferring out to Nebraska Service Center. That's good to know. And so the last thing that I want to kind of talk a little bit now is about trends that we're seeing in adjudication. And I think that a lot of the times what we see, not so much in the context of domestic violence and sexual assault, but I think it absolutely could, is a lot of RFEs coming back defining category and between similar activity and actual qualifying crimes that are covered under the statute. And I think this is important because you can have a crime, for example, like the destruction of property, right, that is considered to be, that could be folded into a crime of domestic violence, even though there might not be an arrest for domestic violence or charge of domestic violence, but absolutely kind of considering the context could be a crime of domestic violence. And so something that I think is really important is to, especially because there's no longer any other box on the supplement B, then they want to make sure that you are putting the qualifying crime into the categories that are enumerated into the statute. And so that there is a recent AAO decision on this, which we can kind of share with you after the fact, that talks a little bit about kind of how it's important to make sure that you are framing these cases as qualifying and making sure that it's both kind of similar in the facts and similar in the nature. And so in this AAO decision, it does kind of talk a little bit about the other statutory definitions of how you might frame harm and how you might also frame what proximate means. And so that kind of looks to other regulations and other cases to kind of make those connections where you might be seeing this issue come up in the context of yours. Usually what we see in these cases come up outside of the context of domestic violence or sexual assault crimes, but I think in as much as you might see destruction of property crime or something else that might actually be sitting in domestic violence or sexual assault, it's important to make sure that you're framing that as category. Maybe cyber stalking as stalking or other issues that might come up in the context of DV or SA. And now I am going to turn it over to Amy, and we're going to get into some polls and some hypos.
Thanks, Cecilia. So as we're going through the next couple slides, keep in mind what Cecilia was showing you guys with respect to the charts, with respect to the number of applications in especially the UNT categories that are being received by Vermont, and keeping in mind how long the backlogs are that you have been seeing in your practice. Okay. All right. So let's go through the situation together, keeping in mind that we're looking at assessing eligibility for relief, right? And so obviously this is going to be important for advising your client to make sure that your client knows what she's eligible for, but it's also a really important strategic discussion because you may find that there are other forms of relief that could be more advantageous for your client. You may also be looking at filing for multiple forms of relief depending on what the situation is. So in taking a look at this hypo, Gloria was working at a store and one of her frequent customers offered her a place to stay at his house. She agreed to move in, but then later he started sexually abusing her, saying that that was the quote-unquote rent that she had to pay. He said if she told anyone that he would report her because she was undocumented. Okay? So obviously there are some additional facts that we would like to know for either a T or a U. There's an opportunity for additional factual development here, but just at first glance, taking a look at this fact pattern, what are people thinking? So there should be a little hand, a little man or a little figure with a hand raised at the top of your screen. And you can vote more than once. So if you think that there could be a possibility for a U here, could you raise your hand? We'll just give it a minute for those to come in. All right. I'm not seeing anything on my screen. I'm not sure technically how this is supposed to work.
So it would show up on the participant list. You can kind of see on the side how many people have raised their virtual hands. So quite a few.
Okay, great. And what about T's? Is anybody seeing a T in this situation or a potential T to explore? Okay, seeing quite a few hands here too, right? All right, so why might it be helpful if people can put something into the chat if they have any ideas for this? Why might it be helpful to apply for both or for a T versus a U? Great. So Yolanda says a T takes less time to adjudicate. Miriam says no cert for a T. Julia, less wait time for a T. Broader waiver for a U. Right. Public benefits for T. Yeah. So we're seeing some general trends here. Shorter processing time, certainly, right? Keeping in mind the numbers that Cecilia was talking about earlier, you're looking at a year, perhaps even a little bit less than a year for a T to get a final approval. We've never hit the cap. There's no wait list. Versus for a U, you're looking at 3.5, 4.5 years, right? There are also public benefits for T applicants. And yes, there are some additional facts that we would need in terms of helpfulness for both, right? But I think these are some important strategic considerations to keep in mind as we're advising clients about their eligibility for different kinds of relief.
Right, and Amy, I don't know if you're going to cover this, but if we can, what facts, maybe if anyone could put the chat in the chat box, you might kind of think this might be kind of in the T form of relief. So for those, the 16 of you who raised your hands for a T, what facts do you think might be kind of relevant to that assessment? Okay, that. We'll be holding documentation hostage. Elizabeth says the sex exchange. Oh, go ahead, sorry.
No, that's right. We've got here sex in exchange for rent, right? So one of your critical components in a sex trafficking case, right, keeping in mind that there are sex trafficking cases and labor trafficking cases, but in a sex trafficking case, we need to keep an eye out for whether or not there was a commercial sex act, right? And so if you're trying to establish that sex trafficking took place, you're looking for, was there a sex act in which anything or value is given to or received by any other person, right? And so this is kind of a broad use of value here, right? And then if you look at the language that the customer was using here, he said that the sex was the quote-unquote rent that she had to pay, right? So we're potentially looking at sex in exchange for something of value, i.e. rent, in the situation, right? And so you can look at trying to characterize the abuse in a way that will fit it into this commercial sex act box. And then, as people were saying, there were threats, right? There was a use of sexual assault for payment of rent. There was threats of abuse of the legal process, right? And so in T visas, unless you're looking at sex trafficking of a minor, both sex and labor trafficking victims do need to show force, fraud, or coercion, right? And so when you're talking about coercion, serious harm, including psychological, financial, or reputational harm, and it includes threatened abuse of the legal process, right? So we're looking at things like who is holding their documents, how much freedom of movement do they have, right? There some intake questions that you can use when you're screening for T-visa elements when you're working with U-visa clients to see whether or not there could be something there for a T-visa as well. For example, sometimes in the domestic violence context, you could see labor trafficking as well, where the abuser is perhaps forcing or coercing your client to work for his business or to work for him, right? You could have labor trafficking in that context as well. And then, of course, you have the other requirements for T-visa eligibility, including that they have to be physically present in the United States on account of the trafficking, right? This doesn't necessarily mean that their last entry was a result of the trafficking, but rather that they're currently physically present here on account of the trafficking. They would also need to show that they would experience extreme hardship were they to be returned to their country of origin. And then there is also a helpfulness requirement, although as someone pointed out earlier, there is no requirement that you get a law enforcement certification of the helpfulness.
So in those cases, where they don't need a certification, what types of things could you use to show that you have kind of made reasonable attempts to help in the investigation or the prosecution of trafficking, absent it's called absent the 914 sub-B?
Yeah, so it depends. I'm seeing in the chat box that Elizabeth has said email exchanges with law enforcement. That's certainly an option. I'd also like to highlight that there is a trauma exception for the helpfulness requirement in the T-visa context. So if you have evidence such showing that your client is too traumatized to cooperate with law enforcement in an investigation, that you could avoid having to file a report at all. If your client does not qualify for a trauma exception, then she does need to at least report to law enforcement. And in the absence of a certification, you could have email exchanges with law enforcement where your client is reporting and expressing willingness and interest in cooperating in any interview or investigation, filing a police report. Certainly, there are a number of agencies, including the DOJ, FBI, Department of State, and HSI, as well as local police and state police, to whom your client could report. Your client can also call the Polaris hotline, which is a 24-hour anti-trafficking hotline. And the advantage of that is that they can help the client to contact the appropriate law enforcement agency. If your client has been asked to participate in any interviews or the investigation, then you can document that as well. And typically, the attorney would also provide their own affidavit as to the client's efforts to cooperate with law enforcement with reporting the trafficking. Do you have anything else to add there, Cecilia?
No, I think that, how many people in the context of the domestic violence, and this could also be a raising of your virtual hand, already kind of do ask questions and kind of do the extra screening for T-visa elements? Is this part of people's already kind of standard intake? All right, Allison, Elizabeth does it, and then Evelyn, Megan, Anthony, this is great. So quite a few of you are already kind of doing this. And so for those who this is not on their radar screen, I think it's important to kind of make sure that we're kind of asking questions about, whether or not this is, as Amy just said, kind of looking into these deeper elements of forced fraud and coercion. Do people feel like they can't, if the documents are being withheld, whether or not they feel free to kind of leave either an employment situation or something else is happening in the commercial sex arena, that we're asking these additional questions to do these screenings for T-visa elements, because there is, there can be a very strong link between domestic violence and trafficking. And so making sure that we're kind of going that extra, asking those extra questions. And Amy, I think the only other thing that I want to kind of focus on here is, the on account of, often, the physical presence in the United States on account of the trafficking. How do you see that being kind of an emerging trend in maybe cases like Gloria's or because that oftentimes I think can make the difference between whether or not you're filing for a T or for a U. Do you want to talk a little bit about that?
Certainly. So with physical presence, as I mentioned earlier, you don't need to show that your client was physically trafficked to the United States, right? Perhaps she entered the United States for reasons unrelated to the trafficking and then later found herself in a trafficking situation. One of the things that I found really helpful in showing physical presence is showing that she needs counseling and access to other social services in the United States in order to recover from the trafficking victimization. And this is where the public benefits really comes in handy, as people were saying earlier. Sometimes you're not able to find free counseling, and so you need financial assistance to get that, and sometimes those public benefits can be really helpful for somebody to get that evidence and to get that counseling that they actually need. Also, if your client is receiving TVAP benefits, the social worker who's administering those benefits can provide a letter about the services that they're receiving, which are all on account of their trafficking victimization. And so there are a number of different arguments, but those are some of the ones that I've looked closely at. Also, sometimes it's been a relatively recent trafficking situation, and the documents could still be being withheld. Your client may be not able to leave the United States because her travel documents are being withheld by her trafficker. So there are a number of different reasons to explore here, but it is a required element for T visa eligibility. It's typically easier to show a physical presence on account of trafficking when the trafficking was relatively recent. It can be a bit more challenging if the trafficking occurred several years ago. So that's something to keep in mind as well.
And we have a question about whether or not reports just to the hotline is sufficient for meeting the reporting requirement. What are your thoughts on that, or is there usually some other kind of secondary proof that you would need for helpfulness?
So I will say that I have never only reported to the Polaris hotline, partly because when you call the Polaris hotline, they will refer the case to a law enforcement agency. And so I've typically either followed up with that law enforcement agency afterwards or reported independently to another agency. So if other people have other experience, please feel free to share that in the chat box so that we can all learn from each other. But I would typically recommend filing a report with a law enforcement agency in addition to just calling the Polaris hotline.
Right, I would agree. I would think that there probably would need to layer of, or an addition of proof you would need to show.
All right.
Okay. How do we deal with inadmissibility, Amy?
Everybody's favorite topic. All right. So obviously inadmissibility is a running issue in all of our cases. And so it's important to be able to identify potential problem areas and figure out how to address those if possible. So let's take a look at this next typo. In 2015, Tara enters the U.S. without inspection, along with her 2-year-old daughter. She marries Simon, a U.S. citizen, who becomes so abusive that she leaves the U.S. And then in 2017, she returns iwi without inspection 4 months later because Simon insists that he will change. Right? So we have a poll. So which inadmissibility grounds do people think apply so far? So if you wouldn't mind taking the poll, and then we can go over the results. All right. So it's looking like we've got more than half of the group saying all of the above. And then we've got some unsure. One person says permanent bar, and then we've got a couple in the other categories as well. Okay. Cecilia, let's talk about, let's stay on slide 15. All right. Actually, I'm going to go back one slide. So let's talk about these grounds that were in the poll, right? So the first one was EWE, right? So it says here that she EWE'd in 2017, right? Because Simon insists that he will change. So Cecilia, how does EWE apply in the VAWA context?
Well, I think that we need to kind of break it down a little bit more and kind of explain what EWE is, right? So, and EWE, as an acronym, is entry without inspection, which means that you arrive in the United States without passing through, without proper documentation. And so that is kind of the first ground that I think it would apply, right? And so how it applies in the VAWA context is ordinarily entry without inspection, right, is not necessarily, and there's some important guidance on this and important, I can put that in your chat box, but ordinarily that would not be a bar or an eligibility issue in applying for a VAWA self-petition. But I think even in that first sentence, right, so we know that the EWE ground of inadmissibility applies. What else do people see as a part of that very first sentence, which also can be an inadmissibility issue? Just in that first bullet point. All right, Catherine says smuggling. Right, and so what is the issue here? So I think they're right. So even that first sentence, we have two inadmissibility issues that apply here. And so, Amy, how would that apply? Or do you want me to talk about how that would apply in the VAWA context?
Well, so smuggling would, in the VAWA context, is going to be a ground of inadmissibility at adjustment, right? And it could also be a consideration for good moral character as well. But one of the things to keep in mind when you're looking at inadmissibility is the fact that your client's inadmissible doesn't necessarily mean that she's not eligible for relief, right? Because even if she's inadmissible, you're also still looking at whether or not a waiver could apply in that situation. Because if she can get the inadmissibility waived, then she could still be eligible. Okay? In terms of the good moral character issue, so Vermont Service Center takes a position that where there's an indication of a lack of good moral character, even outside the 3-year look-back period, that they can still consider that for good moral character purposes. This is, depending on the date, also still within the 3-year look-back period. So you're looking at a smuggling issue for good moral character as well. There are some really helpful memos from USCIS on how they do the good moral character analysis that are available on the SESTA website. They're also Googleable. I think the question here, Cecilia, is going to be whether or not there is any connection between the smuggling and the marriage to the abusive U.S. citizen.
Right, and I think here you have to kind of look at the other general waivers that are available for smuggling, kind of in addition to kind of looking at it from the VAWA context. For example, there is a waiver for smuggling that applies to, it's a very limited waiver, that the person must have smuggled only kind of a spouse, parent, son, or daughter, so it's an immediate relative. And so they had considering that it has to be very limited circumstances. So I think outside of that family member, that there might be a waiver available kind of in that context, depending on who it is. In this context, it is a daughter, it is an immediate relative, and so there might be a potential waiver for inadmissibility that would be available in this particular context.
Before we move on to the next ground of inadmissibility, I just wanted to return for a second to the topic of EWE. So as Cecilia was saying earlier, typically in a VAWA case, an EWE would not be a bar to adjustment. And it's a little confusing if you look at the statute because the exception that's written into 212A for EWEs and VAWA self-petitions is very restrictive in its language. But then when you look at 245A and C, that's where it becomes clear that the EWE is not going to bar a VAWA self-petitioner from adjusting status.
And I'm going to put in the chat box the memo that talks a little bit about the 2008 memo that talks about adjustment of status for VAWA self-petitioners who are present without inspection. And so I think it's also kind of additional guidance and additional instruction around that. But I also want to kind of come back to Amy's point and really reiterate that you're looking at the smuggling and you're looking at it with the two lenses. You're looking at it with the lens of inadmissibility, but you are also looking at it through the lens of good moral character, right, and the bars that apply at 101F. And so, yes, the EWE is the exception. So we're talking now about the waiver for smuggling. Sorry for the confusion, Kifa. And so I think it's really important that we're looking at those issues through those two lenses. This was in 2015. So it's presumably within the 3-year window, so it's something you're going to have to think about. So, shall we move to the second bullet point and what rises there? Amy?
Yep. Oh, sorry. I thought you were having people put them in the chat box.
Oh,
So,
we can.
In the second bullet point, so we see that she left the United States, right? And so let's say for the purposes of this, she left the United States in 2007 and then EWE'd 4 months later, also in 2017. Sorry, did I say 2007? I meant 2017. So she EWE'd in 2015 and was here until 2017 when she left the United States because her USC husband was so abusive, right? And so is anybody seeing any potential inadmissibility there?
Right. What do we see as a problem in the second bullet point? You can put it in the chat box.
Yep. So we're seeing some trends here. We've got permanent bar, unlawful presence, and permanent bar. Everybody seems to be in agreement. So with her departure in 2017, she would have triggered the unlawful presence bar because once she entered in 2015, she began to accrue unlawful presence. And she accrued over a year of unlawful presence before she departed the United States in 2017, and that departure triggered the unlawful presence bar, meaning that she wouldn't be eligible for adjustment for 10 years. Okay? And then we've got a number of people noting that she could be subject to the permanent bar, right? And so let's look at the second part of the second bullet point, where she returned EWE 4 months later in 2017 because Simon insists that he's going to change. And it's the second EWE that is going to make her subject to the permanent bar here. Okay. All right. So, but still, like we were talking about earlier, there's an exception for EWEs and VAWA self-petitions. There's potentially a waiver for the alien smuggling. With the unlawful presence bar and the permanent bar, you're also looking at a potential waiver where there's a link between the accrual of the unlawful presence or the departure or the entry and the abuse. And I'm seeing your comment from Miriam assuming that she was an adult. Yes, that is true, right? So you wouldn't accrue unlawful presence if you were still a minor. But let's assume for the sake of the hypo that she was an adult here. And then there's also a helpful memo from USCIS addressing the unlawful presence bar in the VAWA self-petition context. to make it clear that where there is a link between the abuse and the accrual of the unlawful presence, the departure, the reentry, that a waiver could be available. Cecilia, did you have any other comments there?
Nope. And I also, yeah, so it seems like even, I think just to make the point that even with fairly simple facts, they can also kind of have, various complications that, can come up for thinking about these cases.
All right. So we've already talked through some of these at this point, right? And so there was the iwi, there was the smuggling, unlawful presence, and permanent bar, right? So we are looking at potentially all of the above, although there is the exception for the iwi and potential waivers for smuggling, ULP, and permanent bar. All right. All right, so in light of these facts, if you were Tara, or if you were advising Tara, what would she apply for? What could she apply for? Great. So it's looking like we've got a majority of people saying both. Some people saying you or VAWA, and then we have neither. So you guys are right. Both you and VAWA could theoretically be an option here. Obviously, we would need to do additional factual development. Was the abuse ever reported? All of that, right? But let's assume that all of that is true. She could, in theory, apply for both. And that might be advantageous for her because with the U, there's a much, much broader waiver available. And so she should be able to waive the iwi, smuggling, unlawful presence, and permanent bar with the U. With the VAWA, the processing time is much, much, much shorter than it is for the U, right? And so in the meantime, even if she were not able to adjust into the VAWA, she could still get deferred action and work permit in the meantime while she's waiting for the U to be adjudicated. Did you have anything to add there, Cecilia?
Nope.
Okay.
Nope, I think everything was great.
Great.
And I think yeah, because you're going to have to do it for VAWA, you're going to have to look under the both analyses of good moral character and admissibility. Whereas in the U context, you're looking at it kind of purely within the G14 context of inadmissibility grounds. So I think kind of looking at it, you're going to have to kind of apply different lenses and different screens and looking for these different forms of relief.
Great. All right. So next up, as Simon was withholding financial support for her and her daughter, Tara was arrested for shoplifting basic necessities from her local grocery store. She entered into a pre-plea agreement, completes community service, and the case is dismissed. So looking at this hypo, what impact do you think this could have on the VAWA or the U? What are you concerned about here in looking at the scenario? Right, we've got CIMT, we've got GMT. I'm going to say that's probably good moral character. Okay. Good moral character. All right. So it looks like we've got a number of responses that this could be a potential crime involving moral turpitude. It could potentially have implications for her good moral character for her VAWA petition, right? So Cecilia, why would it be important in terms of her inadmissibility that she entered into a pre-plea agreement?
I think that it's important because you have to look at the INA and kind of how it defines conviction, right? And I think that if a adjudication of guilt has been withheld, or if you've maybe entered into a no contest or guilty plea, or you have admitted facts sufficient to warrant a finding of guilt, so that can still be a conviction for immigration purposes. And so it matters here that this is pre-plea, because that would be something to consider whether or not it actually kind of meets the definition of conviction necessary to kind of trigger inadmissibility grounds like CIMT.
Right. Because for a lot of inadmissibility grounds relating to criminal conduct, you're looking at whether or not there was a conviction. And for CIMT, it's true that if you were to admit to the conduct, even if you weren't convicted, that you could still be subject to this ground, but let's say that she hasn't admitted to this, right? So if you're looking purely at her criminal record, the fact that it was a pre-plea agreement and that the case was ultimately dismissed should allow her to avoid being inadmissible for a CIMT. Okay? Whereas had she entered into a plea agreement where she had to plead and then do community service and then the case was dismissed, that would still be a conviction for immigration purposes.
Right, and the definition of conviction is at INA 101A48A. So you can kind of put that in your INA citation.
And I think this kind of situation really also highlights how important it is for immigration attorneys to coordinate with our clients' criminal defense attorneys when they're facing criminal charges. It's incredibly important to make sure that your client is not pleading guilty to something that's going to cause negative consequences for her down the road with a pending application or with an application that she would otherwise be eligible for. Right.
Deepa raises a really good point. So it says probation before judgment in Maryland is conviction under the INA. So it's really important, I think, to check with the case law on this type of disposition and what might be the case in your own individual jurisdictions. Thanks for that point, Deepa.
Yeah. I think one of the best resources for trying to figure this kind of stuff out is coordinating with the public defender office in your area. There are some public defender offices that will have in-house immigration people to help them advise on immigration safe plea deals and things like that. But coordinating with your PD office can also really be helpful for understanding better what these different procedures and terms mean in the criminal justice system and how that might affect your client.
Right. And those of you who are concerned about, we can go back for just a second, for good moral character. Oh my gosh.
It has a mind of its own.
Runaway presentation. So for those of you who are concerned about good moral character, I think, Mariana, you are, I guess you are, and other ones, Shannon. What do you think is going to be kind of a narrative that you can put forward to address this issue for good moral character in the context of VAWA? What do people think is a way to address this issue if it comes up in your case? Right. So what Miriam is saying, and hopefully Erica, Shannon, and others, that it was related to the abuse. One of my favorite USCIS memos, and Amy, I don't know if you have a favorite. I'm not going to let you list your favorite now, but if you have a favorite, I would like. This is my favorite because I think it is really useful in framing out determinations of good moral character in VAWA self-petition. And so it is really useful kind of in setting up your analysis. One, does the bars to good moral character at 101F apply at all, right? Would their waiver be available? And is there a connection? Is there a nexus to the battering or extreme cruelty that one faced in a domestic violence situation? And I think that, what do you think based on these facts? Is there a nexus between the good moral character concern and the abuse? How many people think there is? You can raise your virtual hand. this is great. I hope to see 155 hands because this is, yes. Obviously, as Yolanda said, that it's a result of economic abuses, result of withholding financial support in order to kind of get the resources that they need. So I think I recommend this memo if you run into these facts because you can absolutely, I think, see that there's, and this happens all the time, right? This happens all the time where there is, you know, I've had clients who, you know, have been, you know, the abuser was choking her, and so she scratched his arms to get off of him, and then she was arrested because she didn't speak English and her abuser did, right? So I think these criminal issues that arise in the context of domestic violence is very common, and which is why I like this memo because it does lay out a framework in thinking about that nexus kind of analysis to these determinations of good moral character. On our next webinar, Amy, I'm going to ask you what's your favorite memo.
I'll be sure to pick one. All right, so we've talked about the first couple here, but then we also have this question of, is she now going to be at additional risk of removal, right? So looking back at the situation at the hypo, she was arrested for shoplifting, right? And so depending on your local jurisdiction, depending on their level of coordination with ICE, she could potentially be looking at a risk of enforcement here because of this encounter with law enforcement. Okay. So you could potentially be looking at worrying about removal proceedings for her, because regardless of the fact that the case was dismissed, she's still EWI'd, right? And so she would still be removable, and you're still looking at some potential immigration consequences here for her. All right. Cecilia, I think you're up.
I am. Thank you for that, Amy. So some other trends that we are noticing in the adjudication of cases is that USCIS, if people do have some kind of criminal history, is that they're asking for police reports, even in cases that have been long dismissed, or even maybe in cases that where it just might be an arrest. And how many people are seeing this as a trend? If we can kind of, can we put down the hands, Alicia, and then do it again? I don't know how to do that. Okay, so how many people have seen this come up in their cases? You can raise your virtual hands where USCIS is asking for police reports for maybe even there wasn't something that, whether or not it resulted in a conviction that your client was. Okay, how have you approached this? So oftentimes we see this come up in the context of RFEs, for requests for further information. So how have people kind of approached this case or this issue? Okay, so Megan says certified dockets and final orders, but not police reports. Right, and I think that what we're seeing as a trend from USCIS is that they said that they are not looking, they're not looking at police reports to determine inadmissibility, right? Because there's case law on that says that to assess inadmissibility, that police reports are inherently unreliant documents, but that they are looking at police reports for discretion, that they're looking for police reports to determine kind of bad behavior or bad actor in their kind of assessment of discretion in these cases. And so I think Carly mentions the point where sometimes police reports are great, right? Like if we're trying to use them to prove battery or extreme cruelty or to show that there was harm, you know, that they can have information that are really helpful to the case. But oftentimes if they have something that's related to your client's own criminal history, maybe related to or unrelated to this case, right, that they might have some really damaging facts and negative facts. And so I think that there might be an argument to be made that they aren't material and they aren't kind of legally kind of inherently unreliable documents. So sometimes they can be more prejudicial than probative. They're not subject to cross-examination, and so there might be some kind of due process issues in asking for these police reports. And I think it's important to make those arguments. But the reality is that sometimes we're seeing cases that are being denied if police reports aren't being reported. And so I think something that we can help you think through if this is coming up in your cases is to contact us, to let Amy and I know if this is coming up in your case. And then we can kind of talk through a little bit of kind of the back and forth and the analysis around these issues. But so they're asking for them. And I think that it's important to know that and to be prepared for that. And so we can kind of say, you know, here's the reason, like here it is, and here's the reason why it shouldn't be legally or factually, they're unreliable. But also, you know, depending on what's in them. So I think it's a case-by-case determination, and I think that we are seeing denials that are a result of people who are not putting them in. Amy, I don't know if you have more to add to this, but I think the bottom line is that if you're seeing this, we would like to know about it, and you can contact us, and we'll tell you how at the end you can do that.
Yeah, I've certainly seen this in my own practice. Cases both where they haven't asked for police reports and also cases where they have. And I've, like a couple of people who've commented, I've also found that if you submit the police report, you can still submit an explanation from your client to explain what the context was, and ultimately it can still be successful even if they're looking at it for discretionary purposes. But it is a case-by-case analysis.
Yeah, so I think that's what we would kind of touch to, Megan. I think that it is kind of case-by-case, and if you are seeing this come up, to let us know, we can kind of have you kind of walk through that with you. And so the interpretation of inadmissibility standards, what this refers to, and I think we're going to talk about it more on the next slide, is kind of how to look at the cases where they are not kind of relying on the inadmissibility waiver standard at 212D14. Which is the waiver that is supposed to be considered in the U visa cases. Instead, they're kind of looking at other contexts. We're going to talk a little bit about the next slide about how to kind of our thoughts on that. The other context we are seeing, and I'm wondering if you're seeing this as well, we would like to know, is that there is an assessment and analysis of inadmissibility that for issues that were once waived, coming up again in the adjustment of status phase. How many people are seeing this? So issues that were waived, maybe you had a 192 that was waived, and they are revisiting these issues in the context of adjustment. So I think Cody, you mentioned that you're seeing this. I'm actually relieved that there aren't more of you who are seeing this. This is something that we have identified as something that issues that were kind of, again, maybe waived in the U context are being RFE'd, being looked into in the context of adjustment. And I think, Melody, I think what you say is very important, is that I think where there is, I think an increased scrutiny, is if there's anything else that came up after the issuance of the U visa. As you know, that there is no 192 to waive additional grounds that come up after the U grant, and that the adjustment under 245M is purely discretionary, right? So you're going to have to frame these arguments. You're going to have to frame them like under what are the positive equities, what evidence of there is rehabilitation, as if you were submitting one, but there is no kind of waiver in the same way at the time of adjustment. And I think it's something that's important is like before, I think there was the practice to kind of say, I am sorry for these and all the sins of my past in the context of 192. So, and please USCIS waive any other ground of inadmissibility that you determine applies. So there is this catch-all language that we used to use, and I think that our framing of this in the 192 context has changed, and that if it's not named in the 192, that it's not waived. And I encourage you to even go down to the very little I of the citation, because it's going to be important that, especially I think in the context of consulate processing, that you make sure that the full ground of inadmissibility is put in the 192. Because we have had issues where consular processing, where post has said, you know what, you only waived, 212, 212A6, but you didn't tell me if it was A or if it was little 1 or little 2. And so that's why I think it's really important to kind of specifically spell out which grounds of inadmissibility that you're asking to be waived in these cases. So I want to talk about framing inadmissibility grounds. Oftentimes, if we get RFEs or we get NOIDs or we even get denials, the Citizenship and Immigration Service often sets forth the factors under matter of RENCA, which is the waiver and the framework for looking at inadmissibility under INA 212D3. And that has a three-pronged approach to looking at inadmissibility. What is the risk of harm to society if the applicant is admitted, the seriousness of the immigration or criminal violation, and why the person wants to remain in the United States. And so, again, in the U visa context, Congress created a different waiver. They created 212D14, which is that, anything is potentially waivable except for the grounds of genocide or being a Nazi, if it is in the national or public interest. And that has not been defined in regs or in case law. And so it's really, I think, an opportunity for us to kind of put forth what we think that means. And I think that we have to be mindful that it is beyond just the interest of the applicant or their family in remaining in the United States, but also what is the community interest. And I think to that end, we have to look about the congressional intent in establishing the U visa program to begin with, which is, one, it was created as a tool for law enforcement to investigate and prosecute criminal activity, and to provide protections for victims who come forward. So this is why kind of how your client might have participated in the investigation, what it meant for him to give a victim impact statement, to go to court, to kind of be a part of increasing kind of public safety in their community. And also we put forth what is called the good neighbor test. The adjudicators in Vermont and Nebraska, they're not lawyers, right? So you can kind of put all this fancy language in case law, but I think that what it comes down to is would the adjudicator in Essex, Vermont, or Carly, you can tell me where it is in Nebraska, would they want your client as their neighbor? And so I think, we're putting in evidence of maybe the involved in a community group, or I've had people tell me that they've shoveled snow for their neighbors, right? So what are those facts? How are they involved in the community? How are they involved in their neighborhood, maybe with their faith organizations, which is important evidence, I think, in showing positive equities in these cases, right? And then we can kind of put forth what is what Susan Boyer at the Immigration Center for Women and Children in California puts forth, the 3 R's, right, that you show, especially I think if there's any kind of criminality issue, is that there is responsibility, you take responsibility for your actions, that you show remorse, and most importantly, that you show rehabilitation. So what kind of have you done to make sure that whatever it is doesn't happen again? So this is kind of how we think about framing the D14 waiver. But the truth of the matter is that USCIS is going to come back to us and say, we are looking at it under these RENCA factors. So I think under that, if this is what they're looking for, I think that people have kind of started framing their applications using this as a framework, saying, okay, USCIS, we know that you are going to be looking at this under RENCA. And so kind of putting in their cover letters, spelling out the risk of harm, the seriousness, and the nature of reasons that they want to enter and to remain in the United States. And to that last point, I think it's important to kind of look to other places where there's been hardship that has been defined. You can look to the T visa regulations that kind of have this kind of framework of the elements it considers for hardship. VAWA used to have hardship requirements, and then that is spelled out in another memo. I'll put that in the chat box shortly, that talks about kind of access to services, access to kind of systems and that a person wouldn't have in their home country. What kind of assistance are they getting as because of their victimization that wouldn't be available? And so kind of looking at those hardship factors, there's other places in the law where you can draw upon to kind of show hardship and why someone would want to remain in the United States. And so I think, you know, in the context of domestic violence and sexual assault, it can be kind of what resources will be available back in the home country to help with victimization. Is this person, is your applicant now or going to be engaged with court cases or other institutions that are related to their protection and safety? And so I think if this is what they're looking for, I think one way to maybe prevent an RFE is to kind of frame it in what they're saying applies, but also don't forget that this is what the standard should be, which is in the national and public interest. So I think that there is a tension between these two factors, these two analyses, that even though we think that D14 should apply, the truth of the matter is they're asking for these D3 factors. So it might be a way to kind of head it off of the path since we know they're going to ask about it. Andrea, to your question about inadmissibility grounds, several minor traffic infractions being viewed as a risk of harm to society. If so, I would definitely be inadmissible because I have had several minor traffic infractions, but I have not seen this be an issue. Amy, have you?
I haven't, but I would also really be careful to make sure that the traffic infractions are actually traffic infractions. There are some states where even though something is under the traffic code, that it is actually a criminal offense. So just take a look at the statute for the issue that your client has had to make sure that it is a minor traffic infraction.
That's a really good point. Thank you. Okay, any other questions on inadmissibility that you're seeing before we move forward? Some folks are typing, so I want to give them a sense to finish that off. What about DUI? That's a really good question. So DUI is not necessarily going to be covered in the ground of inadmissibility, but Amy, how do you see that affecting it?
Well, it's certainly a discretionary question, right?
Right.
And adjustments are discretionary. So that's another issue where I would still go through trying to show that your client has taken responsibility for their actions, that they express remorse, and that they show rehabilitation. So this could include evidence of their enrollment and participation in AA classes. It could include a statement from your client about what she's learned or what he's learned from that experience. It could include statements from other community members about what this person has learned from that experience to show that it's not going to happen again, right? You're trying to show that your client isn't going to continue driving under the influence in the future.
Right, and I think that this is something that USCIS does take very seriously as DUIs as a matter of discussion. I think it's something that is fairly serious. Even if it's not a formal ground of inadmissibility, that it is something that they consider strongly as an issue of discretion. And you're going to have to, especially if there is an arrest, you're going to have to mention it on the 918, on the form itself, or on the adjustment application. And so I think heading it off of the path and doing the framework about how are they minimizing the reduced to harm, how long ago was it, what are they doing to make sure that it's not happening again, I think I would still consider the same framework because it is going to be something that they look at very stridently, I think, in the context of discretion.
Yeah. I would also say that in the context of domestic violence, whether it's a U or a VAWA, to the extent that you can tie the DUI to the abuse, that can also be really helpful as well.
Right, exactly. Back to kind of that nexus framework. And I think this comes up not only in the context of DUI, but also with mental health issues, right? And we've gotten RFEs before if there is any kind of addiction issues, or that we sometimes, in the U context, people have been required to submit a medical examination, a 693, kind of talking about whether or not this person is going to be a harm to themselves or someone in the community. And so I think this issue for DUI is not only something to consider in the criminal ground, but whether or not it might rise to kind of grounds of inadmissibility that might come up in the health context of them. Thank you for your question. Let's talk about reinstatement and voluntary departure. So reinstatement, what is it? It's found in INA 241A5, right? And there are certain things you need to kind of look at. So the statute says that if the Attorney General finds that a person has re-entered the United States unlawfully, right? So there's an unlawful re-entry after having been removed or departed voluntarily from a prior removal order. That prior removal order is reinstated from the original date. It's not subject to being reopened or reviewed, that the person is not eligible to apply for any form of relief under this Act, and that they should be removed under the prior order any time after the reentry. So I think it's important to kind of consider that is the framework. So you're looking for an re-entry after having been removed or departed voluntarily under A, and we'll put a space next time, and an re-entry after being, there was removal or lapse after a removal order, and then an re-entry. And this would make someone subject to reinstatement. And so whether or not someone, the part of the statute actually says that they may not be eligible for any form of relief under this Act. And I think in the context of the work that we do, that is not fully true. Because I think given the D14 waiver and the broadness of that, and given some issues in VAWA, that there has been some ways to readjust that. So the issue is that the permanent bar applies, right? Because just like was it Gloria who had that? There was only with a prior order of removal. So Gloria had a prior removal order, and those were the facts, that there was an re-entry, there was a removal order, and then there was an re-entry, and then that will bring into issues of 212A9C and permanent bars. And so we have at Assisted developed kind of a system so where you do have someone who is eligible for a waiver under 212A9C, I think it's 3, which talks about VAWA self-petitioners, is that for that waiver, you have to show that there was a nexus, right? Getting back again to that nexus element, that there was a nexus between the person's departure or reentry and abuse. And so if there is that, and that is a way that the permanent bar can be waived. And again, that citation is 212A9C3, that they can waive it if there's a valid self-petitioner, if there's a connection between the battery or extreme cruelty and the removal, departure from the United States, and the reentries or reentries from the United States. In this context, we have seen cases where people have maybe been subject to domestic violence in their home country and then came in, there was domestic violence. So what we have seen them say, at least in the context of the AAO, if there's unpublished AAO decisions that say, is that if you're asking for a 212A9C3 waiver, that the nexus has to be the abuse on which you are basing the VAWA self-petition. So if there's abuse from like another abuser, right, that it has to be, then that's not going to count. That the nexus has to be based upon the abuse that you suffered in the context of your VAWA self-petition. I don't know if I'm being clear on that. But if you're running into these issues, there is a process that we have developed that there is that nexus, that you can establish that and we can help you set that up. And so we have kind of, you'll need the 601, the 212, and the adjustment applications to Vermont. And then we can make sure that the adjudicator at your local district office is aware of this process and to make sure that these cases are handled appropriately. And for the reinstatement issues in the voluntarily context, you can also address those issues on a 192, which is making sure that you waive both the 212A9C grounds, but also the 212A9A grounds. And that is talking about who have been, individuals who have been previously removed, right? And so I think you're making sure that you're kind of covering both of those grounds, and this is an issue that is coming up for your VAWA and your TV. The failure to voluntarily depart. This is going to be an issue for U visa applicants or U visa holders who are ready to adjust. So there is an adopted decision by the AAO called Matter of LSM. And this adopted decision that was actually turned into USCIS guidance. It says if a person has a voluntary departure order that fails to comply with it, that the 10-year adjustment bar would apply unless the failure to depart was not called voluntary. Again, this only affects U adjustment and not the issuance of a U visa. And failure to voluntarily depart is not going to be an issue in your VAWA cases. There's an explicit VAWA exception, but not for the U visa. And so I think it's important to review this decision if you have clients who are subject to voluntary departure but didn't leave. To be mindful that this is going to be an issue for you at the time of adjustment. And so here are some strategies to address this issue. If you do have clients who are ready to adjust, maybe more than 10 years have gone by since the voluntary departure order was issued, you can look into whether or not there was actual notice. Maybe it wasn't voluntary. I think it's important to think about this in the context of domestic violence, right? Maybe there was some kind of nexus to the abuse that the person actually didn't comply with their voluntary departure order. Right? Could there be prior ineffective assistance of counsel issues, right? And can you actually do a joint motion to reopen and terminate the old proceedings? I think that what we're hearing is that ICE is only agreeing to these cases in the context of when someone is eligible for U adjustment. So I think these are some strategies to address this if this is coming up in your cases. U applicants and removal.
All right. So you may have clients who are in removal proceedings and then they file for a U. You may also have clients who have filed for a U and then wind up in removal proceedings, right? But either way, there are some common considerations for your clients who are in proceedings. So show of hands. How many people have been able to get administrative closure for somebody with a pending U application in the past? So it looks like a number of people have. And how many people have tried, I know this is a very recent decision, but how many people have tried to get admin closure since the AG issued his decision in Castro-Tum? All right, so I'm seeing one hand. In the chat box, if anybody has had more recent experience with admin closure since the publication of Castro-Tum, if people wouldn't mind sharing their experience, I think that would be good to know. So hopefully people have heard of Castro-Tum by now. So Megan says, unsuccessfully attempted, but because why not? That's true, right? There's really no reason not to at least ask for it and let the court tell you what they're willing to do. But in light of Castro-Tum, it looks like admin closure is going to be a bit more difficult to get. So for anybody who has not practiced in immigration court or anybody who's not familiar with administrative closure is a method by which the courts can control their dockets by temporarily shelving cases. And they do this for a number of different reasons. In the U context, they could do this to allow the U visa to be adjudicated by USCIS. And so if the case is administratively closed, then your client would not need to go to court. There wouldn't be any scheduled court dates for your client's removal proceedings. And then the U visa would continue its processing with USCIS. And then in theory, if your client is ultimately granted a U visa, then at least before Castro-Tum came out, you would be able to recalendar the case in court and then hopefully move to terminate. And so that way, the merits of the case would really be addressed before USCIS as opposed to court. The issue in Castro-Tum was that the Attorney General, Sessions, certified this case to himself for consideration about whether or not immigration judges have general authority to order admin closure. And his answer was no. And so after this decision, we would anticipate that it will be much more difficult to get administrative closure. It probably will depend in large part on where you are and the disposition of the judges in your area. There are some specific carve-outs in the AG's decision. So there are a number of regulations and settlements that provide for administrative closure, such as in the T visa regulations, but there's no such regulation in the U visa context. And so it's probably going to be a bit more difficult to get admin closure these days. But as Megan says, why not try? And I'm seeing Daniela in Baltimore that the judges are still willing to consider motions to admin close on a case-by-case basis. So it's definitely worth trying, and you guys know your local judges better than we do. But the lay of the land has changed a bit since Castro-Tum came out. All right, so what does this mean for your practice? You may have cases that were previously administratively closed. What are you going to do about it? So in Castro-Tum, the judges have not been instructed to recalendar these cases on their own. Rather, the cases would be recalendared if either party files a motion to do so. Typically, for our side, people representing the U visa applicants, we probably wouldn't be the ones filing motions to recalendar unless our client has either obtained a U and you're in an area where you can terminate with the grant of the U, or your client has adjusted already, right? What could happen, though, is that DHS could file a motion to recalendar the case. And so you want to take a look at your case list to see, of your cases that have been administratively closed, where are they in the U visa process? Right? How close are they to adjudication? Are there any that have been adjudicated already, right? And what are some of the issues that you can anticipate going forward with Castro-Tum? And Cecilia, do you want to speak about what are the, why it's important to know what inadmissibility issues are at play in the case? Cecilia, are you still on?
Oh, sorry.
All right.
Yes, I'm here. I'm here. There are I think two issues, right? I think that you have to be aware of inadmissibility issues that come into play that would come up in the context of wire and removal proceedings. But also, I think you need to look at the fact of what have you already put in that application, right? What grounds of inadmissibility that might not have been on the radar screen, or what did you talk about, which may now be in play. So I think it's important to kind of think about that in that context as well. Like, one, is there something that you kind of had on the table before that is now going to be an issue? And two, what is in that application, and how is that going to be considered if your case is reopened or recalendared?
Great. And then also, if your case is recalendared, then what are some remedies and strategies to consider, right? So we'll be talking later about arguments for continuances for pending U visas. What are some alternative remedies that might be applicable in your case? For example, asylum and withholding your CAT, right? Cancellation. And so this is a time to start strategizing to see whether or not your client could be eligible for something else that could be filed with the immigration court. And then also in terms of the practicalities of some of these kinds of cases, you might have inherited a case, or a case might have been transferred to you that was administratively closed by another attorney. And then unless that attorney filed a motion to withdraw with the motion for administrative closure, that attorney is most likely still attorney of record on that case. And so it could pose some questions for you in terms of notice of hearing. Should DHS move to recalendar the case, they would be serving the motion on the attorney of record. And then if the court were to grant that motion to recalendar, that order would be also served on the attorney of record, and then the notice of hearing would also be served on the attorney of record, right? And so that's something to consider in terms of how you're going to make sure that you know what is happening in your client's case, whether it's a question of calling the EOR hotline on a regular basis to see what's going on, or coordinating with your client's former attorney to figure out how you can handle it. There are also issues around changing addresses. Some of your clients may not have been filing their change of address forms with the court once the case had been admin closed. So even if there wasn't an attorney of record, how is your client going to get notice of the hearing if the case does get recalendared? So there's some practical considerations here too, with Kestertum and with the possibility that more cases could be recalendared these days. All right. So next up, let's talk a little bit about other strategies in immigration court when your client has a pending U visa. So there was a memo issued in 2009 that is still good guidance right now for ICE. This has not been rescinded. And so this memo instructs ICE that the Office of Chief Counsel shall request a continuance to allow USCIS to make a prima facie determination on a pending U visa case. Right? And so it's the Office of Chief Counsel who makes this request for the prima facie determination to the Vermont Service Center, and then the Vermont Service Center is supposed to respond to them to tell them whether or not your client is prima facie eligible for the U visa. And if the prima facie determination is positive, then ICE should favorably consider administrative closure or termination. These days, it's possible that if you have ICE on board with a joint motion for administrative closure, you could have some judges who would be okay on signing off on that, and you could also have some who are not, right, in light of Kestertum. But also keep in mind that ICE should favorably consider termination in these cases as well. And so this is a really useful memo to look at and useful to consider in removal proceedings when your client has a pending U visa.
Right, and I think that what's important to note here is that there might be a discrepancy between district offices and how this is implemented, right? I think in the fall of 2017, we heard from ICE national, right, that the policy was is that if counsel will seek a prima facie determination, but if USCIS is unable to issue that within 5 days, then they can proceed with removal and proceed with the proceedings. But I think what we're seeing and what we're hearing is that it is largely kind of dependent on, how this, even though this is, as Amy said, this hasn't been rescinded, but I think that there is a huge amount of discretion that is granted to the district office in terms of how they're following it. And if you have trends, if you hear about how this is being implemented, then I think that we'd be interested in knowing that.
Yeah. All right. And then what happens if your client already has an order of removal, right? You could have a client with a pending U visa who was previously ordered removed. And so in those cases, we would recommend that you look at filing a stay for that client, a stay of removal. And so there is guidance on this. There's another 2009 memo that was issued at the same time as the ICE one that also is still good guidance. It hasn't been rescinded either. And so it's useful to take a look at that memo to see the procedures for ERO, enforcement and removal operations, for filing a stay and for their adjudication of the stay for somebody with a pending U visa application. And this memo spells out the procedure for DHS in this case, right? So if they get the stay request for somebody with a pending U visa application, then there's a specific procedure that they need to follow where, again, they need to request a prima facie determination from the Vermont Service Center. And then they have to give Vermont Service Center 5 business days to issue the prima facie determination. And then if that's granted, then they should grant the stay, right, as long as there are no serious adverse considerations. And then this can be renewed as long as the stay is continued, right? And so to the extent that your U visa applicants have prior orders of removal, then filing a stay is also something worth looking into.
Right. And I think the only thing I would add to this point is that if you are also getting pushback, that I think that it's important that there is statutory and regulatory language on stays for U visa applicants. And so I think that is something, because if, ICE comes back and says, what memo? And then you can kind of say, no, like, there's also this statute, there's also these regs, and there is kind of authority that is spelled out on how this is supposed to be implemented. And so I think that is something in particular and unique to stays that I think is helpful to kind of have in your arsenal of argument.
Great. All right. So let's say your client is still in removal proceedings, right? And let's say either their case was never admin closed or maybe it's been recalendared, right? But your client is back in proceedings. So what can you do about this? If your client is not eligible for cancellation, asylum, withholding, any of the applications that could be, that would fall within the purview of the court itself, then you're probably looking at trying to get continuances. And what we've been hearing is that it's become more and more difficult to get continuances, and also that the really extensive backlogs for U visas are making it even more difficult to get sufficient continuances to allow USCIS to adjudicate the U visa, right? And so we're still looking at Sanchez Sosa. For anybody who hasn't seen this already, I believe it is in the files that are in your sidebar. And so this was a BIA decision where the BIA looked at the factors that the immigration judges should consider when they're deciding whether or not to grant a continuance to somebody with a pending U visa. So they're going to be looking at what DHS's position is. They're going to be looking at whether or not your client is prima facie eligible for this U visa relief, right? And so when you're looking at whether or not your client is prima facie eligible, the judge is looking at whether or not your client has experienced substantial physical or mental abuse The judge is also looking at whether or not your client has been helpful to law enforcement, at the likelihood of the approval of the waiver of inadmissibility, and that's all to determine whether or not your client is prima facie eligible for the U visa, right? As I mentioned, one of the issues that we're having is that a lot of these U visas are taking a really long time for USCIS to adjudicate, and so you're looking at requesting multiple lengthy continuances. And so that is getting more challenging as time is going on. But still, it's worth arguing Sanchez-Sosa as binding guidance for immigration judges. Cecilia, did you have anything to add on that?
Nope.
Okay. I see a couple of questions here. Okay, so we should ask for this if currently in proceedings, if already ordered deported, wouldn't filing a stay be risky? There are some clients, so there are some situations in which I would definitely file a stay. So for example, if your client has been ordered removed and is perhaps under an order of supervision and so has ICE check-ins, then I don't think there's anything to lose in filing a stay in that case.
Right, and I think too, we recommend having what we call a pocket stay, right? And so if someone is in proceedings, there's nothing to stay, right? Presumably there hasn't been an order that's been issued. But so if you have someone with like a super old in absentia, right, or if you have someone that we recommend preparing a stay, you know, preparing it, keep it in the file, keep it in the process in case you need it. And so that is kind of what we recommend as a practice, is just to prepare one, is particularly if you think that there is an order that, you know, an old in absentia order or something else that you would want that is going to be an issue. So even if, you know, there's older orders, if there's an order that is on the books, I would recommend preparing the stay, keeping it in the file, and then making sure that if or when everything were to happen, that you would have everything in place. So that, I think, is even so, it's nothing that I think you need to do kind of proactively, but I think it's something that you would want to make sure that you're prepared for. I think it's just part of safety, it's part of just kind of, you know, your case prep.
And then even if the client's removal order is really old, it's still a removal order, right? If it hasn't been executed, the client hasn't left, it's still a removal order that's on the books. And so if ICE were to ever encounter your client, perhaps through contact with law enforcement or anything like that, then your client could suddenly come back to ICE's attention and be at risk of removal. And so that's why it's important to have the stay prepared just in case.
Right. Gail calls them a pocket stay, just to kind of keep one in your pocket in case you need it. All right. So I think it's important if you do have these cases, and if you're requesting a continuance based on Sanchez-Sosa, that you make sure that the process is being followed and that you are making the record. There are some really interesting BIA cases, unpublished BIA cases, in which they talk about how IJs are not making sufficient findings as required under Sanchez-Sosa. And so, and they're not addressing whether or not the U visa case is prima facie approvable, especially if there's evidence that there's in support of the U visa, that the IJ should make the full record in making a prima facie determination. And so I think there's this language from this unpublished case in 2017 that says that while it's important that the detained docket move efficiently, that IJs have to be mindful of respondents' invocation of procedural rights, and that even if there is a backlog and processing delays, are insufficient in themselves to deny a motion to continue. And so I think it's really important if you are coming up against these cases in which you're going to be arguing Sanchez-Sosa, please do circle in with us and we can kind of talk about this. But you have to make sure that IJs are making the record, because that is part of what they need to do. And so that is why it's just really important that you make sure that the proceedings, that all of these elements as to likelihood of success and everything that is issued as enumerated as part of the analysis and framework, that they're hitting that. And then talking a little bit about how sometimes we see as a position from ICE is that U visa applicants are able to apply from abroad so that nothing is lost. And I think it's important to show that that really undermines the congressional intent in establishing the U visa program, and it's kind of to fulfill, again, circling back to those dual purposes of providing a tool for law enforcement, but also kind of providing protections for victims who are coming forward. So if you have a case and if you're coming up against these challenges, please do circle back with us. Now I want to talk a little bit about 8 U.S.C. 1367 protection. And this is something that I'm kind of, we're coming up again recently. How many people are familiar with these? I know it's getting towards the last stretch of our webinar, so I think, I appreciate your engagement, your virtual engagement as you're winding down your day, or in the middle of it if you're in the, okay, so I see out of 138 people that there are 5 people who know what I'm talking about. So I think this is really important, especially for those who are serving survivors of domestic violence and sexual assault, dating violence and stalking, that you are aware of these protections. And what it is that there are certain, they have been known as confidentiality protections, but I actually think that they're much broader than that. And this is related to kind of 3 different elements of that are for those who are applying for immigration benefits, but not just those who are providing for immigration benefits. So this first one, non-disclosure, means that staff of the Department of Homeland Security, of the Department of Justice, of the Department of State may not release information about someone to a third party, about someone's VAWA self-petition, about their U visa, or about their T visa, except in extremely limited circumstances, like having to deal with national security or other kind of public safety grounds. And so this is important because this protects information about a filed case from getting into the hands of an abuser or a member of the abuser's family. And so this is really important that that these protections are invoked, and they're invoked upon the filing of a VAWA self-petition, about a U visa, or about a T visa. And I think this is important to know because oftentimes the abuser might try to call immigration, might try to call ICE in order to kind of have negative immigration consequences. But there are these non-disclosure prohibitions on DHS staff, on DOJ staff, and Department of State staff, and so that's really important. And this applies in the context of disclosure of information about one of these applicants, right? And this prohibition ends when an application is denied and all opportunities for appeals and denials have been exhausted. So that is the first prong of these protections. The second one is that there are restrictions on abuser-provided information. And so the second prong says that DHS, DOJ, Department of State, or any other components cannot make an adverse decision of inadmissibility or deportability based on information solely provided by an abuser or a member of an abuser's household or family member. And this protection applies, and this is really interesting and nuanced to me, the protection applies to abused spouses and children generally, as well as those who are in the process of applying for VAWA, a U or a T visa, VAWA cancellation. And there's DHS guidance that says that the lack of a pending or approved VAWA self-petition does not necessarily mean that prohibited source provisions do not apply. But similarly, the prohibited source prohibition with respect to U or T visas applies only to applicants for such relief, but even if the victim might be in the process of preparing an application. And so this is really important to know, that DHS guidance says that they might independently corroborate information by a prohibited source, but that has to be done with supervised review and approval. But they may not make an adverse decision about inadmissibility or reportability based solely upon information provided by the abuser. Another interesting thing about this part is that this prohibition may not apply if the person was convicted of a crime of like moral turpitude or other kind of crimes. So if your client has any kind of criminality issues, this that is under crimes of moral turpitude, certain kind of controlled substance offenses, there might be an exception to this, which I think is something that is important to consider under the analysis of how these protections are framed out. And the last one I think is really important. This last one is location protection. This is the third prong of this kind of constitutional kind of framework. And this was put forth, I think, in IRA. And this was codified at INA 239E. And it talks about enforcement actions that occur at locations where victims might be present, including DV shelters, rape crisis centers, supervised visitation centers, a victim service provider or community-based organization like many of the places that you work, or at the courthouse. If the victim is there for a matter connected with a protection order or custody or any other civil or criminal case related to domestic violence, or if a person has been victimized as a U or T visa applicant. And so what this says is that ICE has to certify that it complied with these other protections, that they didn't conduct this enforcement action based upon information solely provided by the abuser. And this certification requirement kind of reflects this congressional intent that, ICE has to be, should be cautious at conducting enforcement actions at these locations to ensure that victims are protected. And so I think it's really important to kind of keep in mind where you might see kind of issues coming up with these location protections. So please circle back with us if you're seeing this, and we can kind of talk a little bit. But this location protection applies to all victims, regardless of whether or not they have anything pending. And so it's just something I think to kind of keep in mind and familiarize yourself. So for the 124 of you who didn't raise your virtual hands, I think it's important to look this over. And again, this location protection is about a certification ICE has to make that they did not violate 8 U.S.C. 1367 in conducting enforcement actions at one of these one of these locations that victims might be. Okay. So thank you for sticking with us. And so we'll take some questions now if you have them. And while they roll in, because I think we have about 7 minutes, I wanted to kind of point out that here is how to reach us. Amy, we're so glad that you're with us, and congratulations on your first webinar with us. And this is how you get in touch with us for anything else that you might need. And so what we try to do in these webinars, ideally, is to help you issue spot. Is to kind of say, here's something that I didn't really think about before, or this is a trend that I think people, that we might want to kind of circle back on. So again, it's not to kind of say, here are all the answers and go forth, but we just to kind of do some issue spotting and to encourage you to please reach out to us. Amy is available for your technical assistance questions. And so we will kind of stay here if you have a couple more minutes. And Amy, I don't know if there's anything that you want to ask?
No, just keep the technical assistance questions coming. So I look forward to working with you all on different case issues as they arise. And if anybody doesn't already know, we do have a particular TA request format that we are requesting that everybody follow. And you can find this, Cecilia, I believe it's on our website.
I will put the link in the, so first of all, we have to make sure that you're registered with us. And that if you're registered, you can kind of ask your technical assistance kind of once you log into our site. And then from there, I can definitely kind of set the form. And if you, I can send that form out. And just give me a moment to do so. Okay.
I'm not seeing any questions coming in.
Okay, so I'm going to say to register, if you haven't already, here's the link that you go to. And to ask the TA question, you would have to log in. And once you log in, you can get it here. All right, everyone, thank you so much for joining us today. We really appreciate your time and all that you do on behalf of survivors and their families. Please do reach out to us for any questions that come up after this webinar or anything else that's coming up in your individual cases. And thank you so much for spending your time with us today. And thank you, Amy. And thanks,
Cecilia,
for running us for us. Thank you so much.